Supplemental is for the duty paid item 1 for submit filing number 4705 of 2025.
Also, I was trying for phone name one serial number 1 to 2. All are arising out of the same date.
Why do you need 4 weeks time?
Also, office is particular.
The applicant has become bankrupt. Then
Limitation.
limitation also is to be filed.
Yes, no, it has come recently. Not the file was sent down for correction. Further action.
It is not barred. Is it barred?
Yes, no,
147 days. Grant till 18th of February is granted to the applicant to remove the defects claimed or to file appropriate petition in connection with one or the other defects claimed. If this order is compliant, close this case on 23rd. Twenty-fourth in supplementary copies. All the cases. Same order.
Serial 1
It is of the council for the applicant has also submitted that all the cases arising out of the same order, same judgment. Let this matter be that.
Item 9 CMP filing number 8138 of 2025.
In this case, not currently around
Defect?
1 extra. Yes. Too many defects.
April of 2006. Four 915 days delay. What is the ground?
Around IM has not been handled for a conversion data.
Same order. 18th तक का टाइम 18 February. Same tree.
4 weeks है application
नहीं काफी है.
क्योंकि बहुत सारा
नहीं
होता है.
Item 10 CMP file number 9560 of 2025.
But there are two defects. But one is defect 2. That in connected case, the applicant number 1 was Neshwar Chamal have expired. So his sons have filed this CMP, who is petitioner number 124.
When did it happen? What is the date of death?
But वो तो नहीं लिखे, लेकिन because his sons are there.
This is defective.
Yes, defect. That is the defect, Lord. That is one of the defect, and one defect is that वहाँ पे जो वकालतनामा जो execute हुआ है, उसमें LTI नहीं लिखा हुआ है. दो defect. Defect number 92 and 120.
This appeal is dismissed as not pressed.
Yes, but I've seen it.
तो इसका क्या होगा? ये रेस्टोर थोड़ी हो सकता है.
But then
A person carrying a wakalatnama says that I have no instruction and the appeal is dismissed as not
yes,
pressed.
I've seen that also.
तो इसका क्या हो सकता है? ये रेस्टोर नहीं करेंगे. A
Not,
person owning a wakalatnama cannot say that I have no instruction and I will not argue with this.
but I understand. But your lordship will नहीं हम वो बोल हम ये बोल रहे हैं लॉर्ड ये डिफेक्ट इग्नोर करके ये सीएमपी में यही लिखा दिया जाए कि हाँ सिंस दिस ऑर्डर हैज बीन पास इसीलिए रेस्टोर नहीं करे तो हम कम से कम लिबर्टी लेकर के फ्रेश तो फाइल कर सकते हैं.
क्या प्रेस करते
मैडम क्योंकि नॉट प्रेस हो गया है.
नॉट प्रेस हो गया तो
बट क्योंकि फाइल नहीं था इंस्ट्रक्शन नहीं था तो हम लोग कुछ कर नहीं सकते थे उसमें.
नॉट तो कुछ भी नहीं करेंगे.
But-
डेड पर्सन आप डेथ सर्टिफिकेट भी नहीं है फाइल करिए डेथ सर्टिफिकेट.
बट ठीक है सर्टिफिकेट फाइल करते हैं लेकिन अपलेंट पिटीशन नंबर 1 to 4 पर उसी का बच्चा है.
अब अच्छा है तो डेथ सर्टिफिकेट फाइल करना चाहिए ना साथ में. डेट ऑफ डेथ भी तो पता चले. 2006 का अपील है, राइट?
हाँ वो तो लिखा होगा।
दिखाई दे रहा 2006 का रिकॉर्ड में। इसको हम रेस्टोर नहीं करने वाले। दिस विल नॉट बी रेस्टोर्ड। आप दूसरा सेकेंड अपील भी नहीं करेंगे। यहाँ पे जो वकालतनामा फाइल करके बोलते हैं कि नो इंस्ट्रक्शंस, एंड इन सेकेंड अपील यू डू नॉट आर्ग्यू द केस ऑफ ऑल द केसेस, जिसमें क्या इंस्ट्रक्शन चाहिए? कनेक्टेड करो।
Second appeal 258 of 17.
एडमिट भी नहीं हुआ था।
ये एडमिटिंग
Appeals stood abated as against response number 3 by the order dated 20/12/2024.
इसी में डिफिकल्टी नोट पार्टीशन सूट है once it is abated is contesting respond to the full
क्या होगा? पार्टीशन सूट अबेट हो गया तो क्या होगा? पार्टीशन अलाउ हो गया था, जो डिग्री सूट
the
was
suit
dismissed
dismissed partition suit dismissed
और ये अपील भी शायद डिसमिस।
appeal भी dismissed plaintiff appeal
क्या होगा इसमें? और फॉर टेक्निकल रीजंस डिसमिसल हुआ है। आपका कहानी तो नहीं खत्म हो गया।
हाँ
फिर इसको रेस्टोर करा के क्या करेंगे? टेक्निकली यू जस्ट लुक एट इट। Will the litigant get anything out of restoration of the second appeal? Will they get anything from restoration of the second appeal?
but there is not
कोई भी आदमी, you see, in a joint family property, एक आदमी फाइल किया, dismissal, दूसरा आदमी फाइल करेगा, लाभ हो जाएगा इसमें। कुछ नहीं है आपके केस में।
इसका खाली डिफेक्ट को
और
सीएमपी
अपडेट हो गया, आप जरा देखिए।
हाँ वो तो
तो नया सूट फाइल होगा तो सारा लीगल रिकॉर्ड्स के साथ होगा।
वो तो नोट्स मेरिट पे लेकिन
कोई रेस ड्यूटी काटा भी नहीं होगा, कुछ नहीं होगा। इसको रेस्टोर करके आप लिटिगेंट को उसके प्रॉपर्टी के फ्रूट्स को दिला नहीं पाएंगे। This is what, you know, if you see it from that angle.
but the lot will see lots
I
our angle
I'll give you plenty time to do it.
but defect तो नोट्स इग्नोर होना है एक डिफेक्ट इग्नोर
आइए फाइल करिए, हम तो ऐसे इग्नोर भी नहीं करेंगे। CMP नंबर 9563 of 2024. Time till 18th of February 26 is granted to the appellant, to the petitioner, to remove the surviving defects or to file an appropriate petition seeking to ignore one or the other defect. From the perusal of the order dismissing the second appeal, number 258 of 2017, it appears that the second appeal was dismissed as not pressed. The counsel for the appellant shall also satisfy the scope as to how the present application for restoration is. If this order is complied, based on 20.
For hearing item 11, second appeal paper 1 of 2006.
I have uploaded the arguments yesterday. You have seen it? You haven't gone through means what? रात को upload हुआ आपने सुबह तक पता ही नहीं. Learned Counsel for the applicant is present. The Learned Counsel has gone through the order passed yesterday, recording the arguments of the respective parties, which has been uploaded yesterday itself. The arguments were already concluded yesterday. The judgment is reserved. I am reserving it. I have uploaded the order of argument of both the parties. She has checked it also.
Yes. And I had sent the soft copy.
From date is for on private cases, orders item was 2nd to 88 of 1984.
Arguments.
तो आगे के लिए
One side.
But before it proceeds, let me note that initially note the file Kalatnama with respect to notes respondent number 2A and 2B, but I have given NOC to them. So far as other respondents are concerned, I am clear.
2A
And 2B notes.
2B, you have given NOC to them.
Yes.
Nobody has filed fresh for that.
No. Note I am appearing for 3A, 3B, 3C, 3D, 3G. So 3A to 3G.
3A
To 3G.
and for rest of the respondents were not.
No.
आइए का सबसे इसमें नोटिस हुआ था जब उसमें रिपोर्ट आया है 2 जन डेथ है 2 डेथ में उसका लीगल एज का कहीं रिपोर्ट आया ही नहीं इंफॉर्मेशन भी नहीं आया
वो हम नहीं जानते.
मतलब वो हम डिलीटिंग के लिए अलग आई लगाए हुए हैं उनका नाम
आइए फाइल की है, डिलीट कर ली. कहाँ है आइए?
आई नंबर है
1301/26.
Yes.
कहाँ है prayer? किसको आपको delete करना है?
ये तो अमेंडमेंट
amendment but amendment उस आई का
ये तो हुआ 5B का और 2 जने का डेट
हाँ
हुआ
दोनों का उसी 2C का भी है 9/5/8/11 5B और 2C रेस्पोंडेंट कुछ अपेयर करके अगर नाम इंफॉर्मेशन अगर आ जाता तो बेटर बट इंफॉर्मेशन आया
रेस्पोंडेंट नंबर 3 थोड़ी है, ये तो रेस्पोंडेंट नंबर 3 है यहाँ।
2 का इनके पास पॉपुलेरिटी यूनिवर्सिटी के चले गए 2 का अपीयरेंस इनका था न्यू क्लास में आएगा शायद वो इंफॉर्मेशन देंगे तो बेटर
कुछ नहीं आएगा, इसको सुन के डिसाइड करें। अब हम वकालतनामा का वेट करने वाले नहीं। वी विल स्टार्ट आवर हियरिंग। पहले तो अबेटमेंट पर ही बहस करेंगे, whether the appeal has abated। सबसे पहला तो आर्गुमेंट वही होगा, whether the entire appeal has abated। क्या करें इनका ये?
But I am perhaps is not clear notes. He is the plaintiff, but they have filed a suit for cancellation of 2 state deeds, 73 and 76. There are 2 state deeds. So far as that 2 state deeds are concerned, that is only with respect to defendant number 3, executed by defendant number 1 and 2 in favor of defendant number 3. So far as 5 is concerned, he is no way connected to that state deed. So therefore, abatement with respect to 5 or respondent number 8 will have no effect in this.
Are they the purchasers of the property?
So,
Are they the purchasers of the property as per the written statement?
but other defendants, that defendant number 4 to 9, are
Four.
purchasers of sale deeds, which sale deed is not under challenge. So therefore, that will not have any effect.
That's right. And they are the purchasers of which property? The same property?
No, different property.
Or
Different property altogether of 78 deed. So I am representing a defendant who has purchased a property from defendant number 1 and 2 in the year 1978, which is not under challenge. And that is
So-
a specific
so they-
paragraph in my written statement.
So their abatement, no abatement has no relevance.
This is not
Whether
having
they want to delete anybody or not delete anybody also does not have.
only 2C, because not 2 is legal heir of defendant number 3, who is Lakhan Lal Saab. So Lakhan Lal is a purchaser, and his sale deed is under challenge. He has purchased by 2 sale deeds. His sale deeds are under challenge. 73 and 76. 2 sale deeds are under challenge. Purchased by Lakhan Lal. उनके बच्चे हैं different 2A, B, C. So 2A and B were appearing through me, although they have taken fine. So I have given them NOC. So I am now in sum and
What
substance.
is the consequence? If 2C is not there,
But they have said since 2C have expired, there is a report, and his lordship has read it has abated against 2C. So they have to come up.
the, what is the consequence of non-substitution of 2C?
But so far as interest of defendant number 3 is concerned, that is being represented by 2A and 2B, two other sons. There were 3 sons, 2A, 2B and 2C. So one have died.
Interest is
Interest is
substantially less.
represented because they are claiming to the same state deed of father.
Okay, so now the substitution is to be known.
But rather it is not a substitution, but they are seeking deletion. Although
No, deletion is one thing.
yes, please.
They are seeking deletion of 5B.
5B and 2C, whom your lordship has already ordered that it has abated against 5C and 2C and 5B. There is an order passed by your
That's
lordship.
right.
Yes.
That's right.
So they are seeking to delete their name at their own risk.
Okay.
This
That's
is
right.
the paragraph 5 of their right.
Yes. That's
So
right.
that can be done.
Because they have not been able to find out the legal years.
Yes.
And their interest is represented through the other legal years.
So as contesting 2A and 2B, they were served. Now at present there is no advocate of them, but they were served.
They were sought 5 wakalatnama and now absent. So IE of 5B कौन सा है? कौन सा IE है? IE नंबर?
यही आइए इसी आइए में लोग अमेंडमेंट का प्रयास किए हैं
किसका अमेंडमेंट का प्रयास किया?
पहले जो आइए फाइल किया
कौन सा IE पुराना वाला?
14039
इनका आइए था 14039 of 25
14039. Yes, 14039. This respondent number 5 was earlier substituted.
So they have filed a substitution
Substitution for
5 and 2, that is on whom notices were issued by your lordship. And now by filing this IA, they are seeking to amend their earlier IA on which notices were issued.
अब बताइए किसका किसका सब्स्टिट्यूशन करना है? इतना सारा लोगों का नाम लिखे हैं आप इसमें। एक आध को तब डिलीट, एक आध का तब रिजेक्ट कर दिए पहले। नाम बताइए। नाम लखन लाल, रेस्पोंडेंट नंबर 2, और उसका और किसका? सॉरी, स्पेलिंग
BUKAN MIAN
रेस्पोंडेंट नंबर 3, और किसका?
Respondent 4 Abdul Karim
और किसका?
Respondent 5 Mahabil Mathur Respondent 6 Agnu Mathur
और कौन सा रेस्पोंडेंट? इसमें से 5A क्या आप डिलीट करना चाहते हैं? 5B
5
5B आप नहीं इंक्लूड करना चाहते हैं,
5
और रेस्पोंडेंट नंबर 2C आप नहीं इंक्लूड करना, करेक्ट? ये आइए नंबर है आपका 14039। किसका कब देखो? This has been filed after the order of the Supreme.
Yes. After the order of the Supreme Court, notices were issued on their first IA. On उसमें सर्विस रिपोर्ट आया कि 2B and 5C का डेथ हो गया. So the lordship has ordered, it has awaited against 2B and 5C. There is a judicial order to this that effect. And then they have filed this IA for deleting them.
Respondent number 4 का तो हम already अब्दुल करीम का हम already reject कर चुके हैं. I've already rejected. कुछ नहीं पता है ना. हर डेट में आप ये सेकेंड अपील 84 में जो है 1984 का सेकेंड अपील में आकर ऐसे ब्लैंक फेस लेके खड़े हो जाते हैं. एक दिन सुबह से 10:30 बजे से लेकर 4:30 बजे तक ऐसे ही खड़ा रखें. Respondent number 4 अब्दुल करीम का तो ऑलरेडी हम रिजेक्ट कर चुके हैं. By order dated 6/11/2025, I've already rejected.
Yes, yes, lordship has.
तो फिर इसीलिए रेस्पोंडेंट नंबर 8 का तो कोई 4 का तो कोई सवाल ही नहीं उठता. लिखिए तो. The learned counsel for the appellant has submitted that IA number 14039 of 25 is in relation to substitution of Lakhan Lal, respondent number 2, Bukhan, Bukhan, Mia, respondent number 3, Abdul Karim, respondent number 4, Mahabir Mehto, respondent number 5, and Agru Mehto, respondent number 6. The prayer for substitution of respondent number 4, Abdul Karim, has already been rejected by the order dated 6/11/2025. और किसका रिजेक्ट किया है? Respondent number 1A का भी कोई फाइल किए थे क्या सब्स्टिट्यूशन पिटीशन? Further the prayer for substitution made through IA number 14039 of 2025 with respect to respondent number 1A and respondent number 1B has also been rejected by the order dated 6/11/2025. ये तीनों का तो डिस्कस कर दिए थे. अब ये बचे. इसका एक कॉज टाइटल हम लोग किसी जुडिशियल ऑर्डर में ड्रॉ किए थे. Where is that? Order. अग्नु
But this is order number 35.
अग्नु में तो है AGH. हाँ वो खाली नाम चेक कर. लखन लाल. The Learned Counsel for the appellant has submitted that one IA number
1301.
1301 of 26 has been filed for deletion of proposed legal year of respond number 2. One of the proposed legal year of respond number 2, that is respond number 2C, and one of the legal year of respond number 5, that is respond number 5B. The Learned Counsel submits that they have not been able to find out the details of legal years and successors of these persons, and has also submitted that their interest and estate is already represented by the other proposed legal heirs and successors of respond number 2 and respond number 5 respectively. And therefore a prayer has been made that the name of respond number 2C, proposed respond number 2C and proposed respond number 5B be deleted. The Learned Counsel, Mr. Ayush Aditya, has submitted that though he had filed Wakalatnama on behalf of respond number 2B and 2A and 2B, but the client has taken no objection from him, and therefore he has no instructions with respect to 2A and 2B. So far as the proposed legal years of respond number 3, 3A to 3G is concerned, he submits that he has already entered appearance. What about 5 and 6? 2 and 3 तो हो गया, 5 and 6, 5 का भी हो गया. Nobody has entered appearance for the other legal years. Nobody has entered appearance on behalf of the proposed legal years and successors of respond number 5. Although as per order dated 5/1/2026, respondent number 5A and 5B and also respondent number 6A and 6B has been served. Considering their future submissions, any objection with their prayer? The Learned Counsel has no objection so far as the prayer for deletion of respondent number proposed legal year of proposed respondent number 2C and 5B is concerned. After hearing the Learned Counsel for the parties, IA number
130.
14039.
That's one.
14039 seeking substitution of respondent number 2, 3, 5 and 6 is allowed. The delay in filing the petition for substitution as explained in the IA number. Limitation फाइल की है इनका अलग से 14044 and the prayer for setting aside is also allowed. The setting aside abatement is also allowed in the circumstances mentioned in the interlocutory application. उसके लिखिएगा इस पर थोड़ा सा 14044 of 25. The counsel for the appellant has submitted that the second appeal was dismissed in the year 19 was wrongly shown as dismissed by this court, and now it has been restored by virtue of the order passed by the Honorable Supreme Court on 25/7/2025. And therefore, during the pendency, when the matter was not being listed before this court, no petition for substitution.
The Lordship will not use the word restored because
Restored name.
the restored name.
Revived. Revived.
No, it was not even dismissed by the High Court. It was held कि respondent number 8 के खिलाफ जो है, and that order was challenged.
लेकिन वो केस चल नहीं रहा था.
चल नहीं रहा. हाँ.
यहाँ पे रजिस्ट्री में नहीं
हाँ,
था.
रजिस्ट्री में नहीं चल रहा था. सुप्रीम कोर्ट में खाली.
It was not being listed.
Yes, not being listed. तो restored तो मिला जाएगा DT हो गया, dismiss हो जाता है.
It was revived for
हाँ,
listing.
revived.
Revived for listing. The learned counsel for the applicant is directed to delete the name of respondent number 2.
Lord, can I have the Lordship's name? Lord, I will just.
Yes. इसको लेकिन हम सुनेंगे अभी. इनसे थोड़ा सुनेंगे. I'll ask him to open the file at least. Respondent number 2, 3, 5 and 6 from the cause title, and insert the name of their legal heirs and successors, the name of one of the legal heirs of respondent number 2, that is respondent number 2C, is deleted, and name of the one of the legal heirs of respondent number 5, that is respondent number 5B, is also deleted from the IA number 14039. आप respondent number 4 को delete नहीं किए, क्यों? क्यों नहीं delete किए? Respondent number 4 का substitution dismiss हुआ. There was a direction to delete his name. There is an office note that you have not deleted it.
फोर का डिलीट किया, 7 का डिलीट किया, 7 का डिलीट किया,
7 का तो छोटू महतो है.
हाँ उसको डिलीट किया, हाँ
उसको कब डिलीट किया?
बाद में
इंस्पेक्शन तो कुछ नहीं है ऑफिस में.
इसका तो कॉस्ट टाइटल है ही नहीं, कहाँ डिलीट किया? इसका तो मेमो ऑफ अपील भी नहीं है. कॉस्ट टाइटल में फ्रेश जो कॉस्ट टाइटल बना है. अच्छा, रिस्पॉन्ड नंबर 7 को डिलीट करिए. रिस्पॉन्ड नंबर 4 को भी डिलीट करिए. ठीक है. चलिए, हो गया सब्स्टिट्यूशन. अब बहस करो. आज भी योर केस 84 सुप्रीम कोर्ट का डायरेक्शन है 3 महीना में डिस्पोजल करने का. अब हम टाइम नहीं देंगे. आपके ऊपर डायरेक्शन बाइंडिंग नहीं है, मेरे ऊपर बाइंडिंग है. 84 का सेकंड अपील टाइम नहीं देंगे. आप बहस करिए. नेक्स्ट वीक कब आएगा? आज ही बहस करना है. नहीं चलेगा. किसी दिन क्या, हर डेट पे खाली टाइम लेने के लिए खड़े हो जाते. क्या है सब्सटेंशियल क्वेश्चन? बताइए, कहाँ है आपका सब्सटेंशियल क्वेश्चन? पढ़िए. इसमें 3 आई है डिस्पोजल में। पहले का 2 है लिमिटेशन सब्स्टिट्यूशन और आई ए नंबर 13.01.2026 ये भी डिस्पोजल। सब्सटैंशियल क्वेश्चन ऑफ लॉ पढ़ने के लिए भी नेक्स्ट वीक चाहिए। आप पढ़िए पढ़िए।
Question पहला है मैडम, whether the suit is in the present form for declaration is having any question related to the adverse position as claimed from the side of the defendant number 1 and 2.
बताइए इसमें एडवर्स पोजीशन का कोई कहानी हो सकता है? सेकंड क्वेश्चन
Whether the plaintiff would suffer due to his non-filing of declaration against the defendant number 1 and 2, challenging the Batwaranama of 1946 on
attaining his majority within 3 years after
3
19.
years after 19.
You were minor, right? When the Batwara had taken place, you were minor, correct? Did you challenge the Batwaranama within 3 years after attaining majority? If you do not challenge it, that is binding on you. जिस दिन मेजर हो गया उसमें 3 साल के अंदर आपको चैलेंज करना, नहीं किया तो कहानी खत्म। समझे ना? ये है सेकंड सब्सटैंशियल क्वेश्चन। ये डिसाइड हो गया है इशू
2025 में जजमेंट है।
प्रेम सिंह में है ना प्रेम सिंह में इसमें यही है।
केस सी वर्सेस
जहाँ तक आपको ध्यान है प्रेम सिंह में यही काम है।
2025 का जजमेंट है। केस सियप्पा वर्सेस एसएमटी के नीलामा
है 2025 में, इनको याद लीजिए। जजमेंट का साइटेशन लिख के दीजिए।
सिविल अपील नंबर 11342 11342
आप है प्लेंटिफ। जजमेंट मिल गया ना इंसान। मेजर होने के 3 साल के अंदर आपको चैलेंज करना है, अदरवाइज योर चैलेंज टू बटवारानामा इज नॉट एक्सेप्टेड। ठीक? जरा बताइए तो किस केस में ऐसा है कि हम ऑर्डर करते हैं that hearing has commenced. He has referred to one judgment. He has referred to one judgment, right? वेडनेसडे को फर्दर हियरिंग 10:30 बजे शुरू करेंगे और तब तक करेंगे जब तक खत्म नहीं हो। ठीक है? The hearing of this case has commenced. The learned counsel for the appellant has placed the substantial question of law framed by this court by order dated 8/7/1996. The learned counsel for the respondent has submitted that the second substantial question of law is covered by a judgment of the Honorable Supreme Court reported in वो report दे दीजिए आपका जो भी। The learned counsel submits that the learned counsel for the appellant submits that for further hearing any date may be fixed in the next week. As per the order of the Honorable Supreme Court, the case is to be decided. Order of the Honorable Supreme Court dated 21/7/2025. The case is to be decided within a period of 3 months. 3 months has expired on account of the pending substitution petitions. However, the matter is directed to be posted for further hearing on next Wednesday as first case at 10:30. No prayer for adjournment will be entertained. फर्स्ट वैसे एकदम टॉप सबसे पुराना केस है मेरे बोर्ड का, इससे पुराना तो कोई नहीं। डिलीशन सब कर लीजिए। आईए में जो है वो 52C एंड 5B को भी डिलीट कर देंगे और सारा कर लीजिए। आज करिए बैठ के इंस्पेक्शन नहीं है बैठ कर लीजिए।
For hearing item Q, second ability of 1994.
This is plaintiff second appeal against the judgment of reversal, Lords. We kindly see order number 6, Lords. Order number 6. Whether on the basis of Exhibit B, the defendant acquired any right title interest over the suit land, and second, whether the finding of the adverse position of the defendant is based on the material on the record. Now, Lordship, I am reading the plaint.
You are the plaintiff.
Yes, I am the plaintiff. The learned first appeal Lordship reversing the judgment only on the ground of adverse position, stating that there is a specific plea of defendant relating to adverse position, but I have gone through the written statement, there is no pleading, Lordship.
Let's
Para 1 Lords of the plaint, Lords, that the lands were fully and particularly described in schedule below here after mentioned a suit land was recorded during the regional survey record of
you
land.
refer to the written statement only.
Yes, written statement. The suit is barred by law of limitation in adverse position. The suit is barred
Why
by
adverse position?
barred by the pleading. There is no plea that he is a hostile position to the knowledge of. There is several
Nothing
ingredients. General Lordship. The suit is barred by different provision of specific deal where the suit is grossly undervalued. The proper value of land is suit along with the house standing therein will be more than 2,000 rupees, 20,000 unless the plaintiff pay the adverse court fee on the said amount. The suit cannot proceed. The suit suffer from non-joinder of necessary party. The suit cannot proceed unless the widow or wife of the Shankar and descendant of the recorded in the arrest Hatal number 12 are implicated in the suit. The suit land is value. It is beyond the comprehension of the defendant as to which portion of the land. The arrest plot number so and so is claimed by the plaintiff. Para 2 of the plaintiff admitted by the defendant. Para 3 of the plaintiff. it is denied that Shankar Mahato is dead. The Shankar Mahato was convicted in a murder case sometimes in the year 1971 or 1972. Since then, his whereabouts are not known. It is emphatically denied that suit land was in possession of the said Shankar till 1979. That Rohini has inherited the land of the Shankar widow. The Parapur of the plaintiff, it is denied that Rohini was in possession of the any land in arrest plot number 126, 127, village Ornati, for that any land is two plots were inherited by said Rohini. Shankar Mahato had no land in this plot in the year 1979. The entire sale of the Shankar was transferred by said Shankar to the defendant as Tharwai in the year 1960. This Shankar had no share to the extent of the so-and-so acres which the plaintiff claimed to have purchased from the Rohini. It is also false that Shankar had or had any son or sons of Shankar have sold any land to this plot. Para 5 of the plaintiff is emphatically denied by the defendant that the defendant paid the rent for the land purchased by from the Shankar Mahato in the year 1960. Para 6 of the plaintiff, it is denied by the defendant that defendant never disturbed the possession of anybody or less possession of the plaintiff. However, the defendant is possession of the land purchased by him from Shankar Mahato in the year 1960. The proceeding 144 CRPC was initiated by the plaintiff only to take forcible possession over the land which is peaceful possession of the defendant. It is incorrect that defendant is claiming land through a false document. The sale deed executed by Shankar Mahato is genuine. Deed through the sale deed, Shankar transferred the land to the defendant on payment of adequate consideration. After the sale, aforesaid Shankar Mahato put the defendant in possession thereof. Shankar Mahato, after sale to the defendant, shifted to village Barwadi, a village situated close to the village of Kornodi, and built a house there. Shankar Mahato took away all the building materials, namely dharna, balls and tiles from the house situated in the land transferred to the defendant. Decided there his arrest in murder case. Rohini was married from the Barwadi. Immediately after purchase, a posted the defendant got his name mutated and paid the rent regularly to the estate of their own possession up to that rent received. That in the year 1961-1962, the defendant built a house in the land purchased by him from Shankar and put boundary wall on three sides, namely east, west, and south. In the northern side, the house of the defendant stands beyond the house of the defendant. There is a village of Chauha. The defendant has excavated a well in the suit land in the year 1963. During the present survey, the land purchased by the defendant from Shankar Mahato has been carved out for plot number 127 and has been numbered as arrest plot number 169.
He claimed title on the basis of sale deed.
Yes, I am purchased the land by virtue of two registered sale deed. He is claiming unregistered sale deed executed in the year 1960 in favor of the defendant.
This is unregistered sale.
Unregistered sale deed. Amount is 300 lordship. I will show the judgment of the learned
That
trial.
is exhibit B.
Exhibit, yes. The sale deed is exhibit 1 by A and 1 by B.
This is your sale deed.
My sale deed.
What about this
Exhibit B is the unregistered sale deed
unregistered
in
sale?
favor of the defendant. An amount of 300 and which is required to be registered according to section 1B of the Indian Registration Act. And there is no pleading of adverse possession, Lordship. Now, Lordship, make holistic findings of
He's
the
claiming it on the basis of sale deed. Whatever
unregistered sale deed.
unregistered sale.
Unregistered. Although there is no pleading of adverse possessions, Lordship.
It's just mentioned adverse possession.
But
And at the same time, he mentions that the defendant never disturbed the possession of anybody, far less the possession of the plaintiff.
But I will show also evidence, Lordship. I will also show the mechanistic trial court, the issue framed by the earlier trial court, Lordship.
In the light of this, let us have a look at the substantial question of law once
Yes.
again.
Whether on the basis of Exhibit B, the defendants acquired any right, title, and interest over the suit land.
So this exhibit B has been believed by the learned first appellate court.
Lord, he is believing lottery arranged.
Who is believing? The court is believing.
The learned first appellate court held that there is a specific pleading, the pleading of the learned the trial court is that he is the possession of the land. But this is the submission of the plaintiff that mere long possession is not a adverse
That's
possession.
right. So far as first substantial question of law is concerned, why was it required to be freed? First substantial question.
On the-
Exhibit B,
Exhibit-
has it been relied upon by the learned first appellate court?
Not relied upon by.
Not relied
Not
upon.
relied upon by.
Then why this question has been raised?
Lord, say I don't understand, Lord. Not rely upon.
Yes, respondent. Respondent, you are relying upon exhibit B. Why this question has been raised? So, should I go to his chamber? Yes. I'm just asking you, why this question has been raised? Exhibit B is your document. And there is no plea of adverse possession. जजमेंट पढ़ाइए बस हो गया हम देख अब जजमेंट बताइए कि देखें कि क्यों एग्जिबिट बी पर बना है इट्स अ जजमेंट ऑफ रिवर्सल
Reversal.
ट्रायल
Trial.
इश्यूज पढ़िए
Yes. Para 3 lots issue criminal penalty. Internal page 5 lots. Issue number 3 and 4 is important lot. Is the stated by Rohini Devi, daughter of Shankar Mato, in favor of the plaintiff legal and valid and has his confirmed title to them as the defendant acquired any right title interest in possession by the alleged sale deed. The finding is para 4 lots. These issues being interrelated to each other and taken up together for the sake of convenient discussion. Admittedly, the suit land belonged to late Shankar Mahato, the father of Srimati Rohini Mahatai, who had got it as his share from the partition of the land under the disputed khata among his brother, co-sharer, and his co-sharer were Nirgan Kawari Mahato, former plaintiff, and Chuttu Mahato, out of whom only the apostate Chuttu is alive, and admittedly suit land is fenced with muddy walls on all around except the north side. It is also remarkable note that defendant does not claim for the land of area 0.3 by 4 decimal under the plot number 126 of the disputed khata number 12. Thus, the land of 0.3 by 4 out of 0.90 decimal under the plot number 127 of the same khata is dispute between the parties. It is admitted fact that a proceeding M46 of 89 under section 144 of CRPC between the Gauri Mato versus Jadhav Mato, which was converted into proceeding under section 145 CRPC on 17/3/1989. It was dropped on 26 October 1989 in the right of the present suit. The learned counsel for defendant has argued that defendant has though an unregistered sale deed in the year 1960 purchased the land about 4/3/4 and plot 127 for 300 rupees from the apostate Shankar Mahato, who put them in possession thereof, and then the defendant built a house in the year 1961-62, but boundaries on the east, west and south exhibited away in the year 1963 therein, and his house stands towards the north at the apostate suit land. That the defendant, after its mutation, paying rent for that land in question has been cut as a new plot number 169 area 0.05 decimal out of a plot number 127. DW1 Niranjan Mahato, resident of village Maheshpur, who is the Mukhya of the Maheshpur Panchayat since 1960, has proved the exhibit B with objection. The plain sale deed dated 17/9/1960 of which execution done by Great Shankar Mahato in presence of two witnesses, Sundar Singh Mahato and Karam Singh Mahato, and he attested the sale and its consideration money, and sale deed was written by the late Fani Bhushan Chatterjee at the instance of the apostate vendor Shankar. The main, that is unregistered sale deed, bears the signature of DW1 at two places on the below and Mukhya and other on the right side corner as identifying witness to it. But none of the Sundar Singh and Karam Karam both still alive has been examined. More important is that the consideration amount of the aforesaid sale was not paid in presence of DW. Aforesaid Fani Hussain was the Gram Sevak of the same panchayat, not a single witness of the defense, not even the Red Narayan Mahato, the Kapari Dadi, son of defendant, could prove the payment of consideration money by the defendant to Shankar for aforesaid. The poor defendant Jaidev got to all to see how many he come and prove it. Thus the aforesaid sale of land concerned without any proper consideration amount is not paid by evidence but invalid in the eye of law. The learned counsel for the conceding to the defect of the aforesaid sale deed being unregistered has further contended, though the provision in the section 49 registration act dictate out to having compulsory registration, yet its proviso say that it is necessary for collector purpose to put them reliance upon the following authority. So and so. I'm beginning para seven.
So this exhibit B
Ji,
was held to be without consideration.
without consideration.
And then the court also.
And witnesses also not supported the case.
Witnesses also not supported the case, and it was held to be void ab initio.
Yes.
And it was not fit for being taken up for even for collateral purposes.
Collateral purpose.
And ultimately, the plea of adverse possession, although argued, and it has been recorded that there is no pleading.
No bleeding.
It has been recorded in the
Recorded, but
what happened before the appellate court?
appellate court laws. Paratil laws. Paratil of the London Appellate Court page 8. The London Lower Appellate Court held in para of the judgment that plea of adverse possession had not been taken in litigation, so it could not be allowed to take the plea of adverse possession evidence from the litigation in para 2 to 12. It becomes explicitly clear that there was a plea of adverse possession and limitation taken at very initial stage, so the decision relied by 98 DVC does not help the plaintiff to the respondent lawsuit. This is main case of the first
Plea
appeal.
of adverse possession has to be taken in a.
There are some ingredients 2006 7 SCC 570. 2006 7 SCC page 570. 2019 8 SCC page 7 to 9.
2019.
8 SCC page 7 to 9. एक और पैराग्राफ
ये 2006 का पैरा कौन सा है?
पैरा 50 और
और इसका पैरा कौन सा है? 2019 का?
बता दीजिए पैरा 57
पैरा
one is also 9082 KIR 9082 Patna 185 para 6 laws.
Yes, what do you have to argue? Adverse possession लिख देने से adverse possession नहीं ना?
ना
इसमें तो कोई डाउट नहीं.
इसमें कोई doubt
अगर कोई डीड से कोई टाइटल क्लेम करेगा, एडवर्स पोजीशन होगा साथ में.
नहीं होगा उसको दिखाना होगा
प्लीडिंग में पहले दिखाना होगा कि किस डेट से पोजीशन में है, उसके बाद वो अपने केस से ये डिफेंडेंट का केस है, और जो हुजूर बोले एकदम ठीक बोल रहे हैं, पहले उसको रिटेन स्टेटमेंट से दिखाना होगा कि कब से पोजीशन में है। अगर डिफेंडेंट है तो प्लेंटिफ है तो 2019 वाला, हाँ डिफेंडेंट है कब से पोजीशन में है, फिर दिखाना होगा कि फ्रॉम द रिकॉर्ड्स कि वेदर ही हैज
Not only from the records, who is the real owner? Firstly, he
हाँ
has to
हाँ
say that the title
इसमें
is
तो इस
not.
केस में हुजूर कोई डिस्प्यूट ही नहीं है कि हुआ द रियल ओनर, इस केस में ये डिस्प्यूट ही नहीं है, उनका प्लेंट देखा जाए।
The defendant was claiming title by virtue of a
हुजूर
sale.
खाली हुजूर केवल ये देखा जाए कि हुजूर जो कह रहे हैं, पहले तो लॉ पॉइंट पे हम एग्री हैं, उसमें लॉ पॉइंट में तो कहीं डिस्प्यूट नहीं हो सकता है, ना तो ब्रदर के साथ ना तो कोर्ट के साथ, लॉ सेटल्ड है। अब ये केस देखना है कि क्या हम तो डिफेंडेंट हैं, प्लेंटिफ का प्लेंट देखा जाए कि उसमें रियल ओनर किसको माने, अगर हम उससे बियॉन्ड जाएंगे तब ना कहेंगे। प्लेंटिफ का सूट है टाइटल सूट 10/1989, इसमें देखा जाए, इसमें सूट प्रॉपर्टी है पैरा 2, मेरे पास रिकॉर्ड नहीं है जो नोट किया, रिकॉर्ड एकदम पोजीशन में नहीं था कॉपी भी लेने का, पैरा 3 देखा जाए, जजमेंट तो दे दीजिए, क्योंकि सीनियर ब्रदर लाया जजमेंट उसी पे हम ही रिलाई कर ले जाएंगे, उसी पे हो जाएगी। जो प्लेंट में है हुजूर को मिला। नाउ काइंडली माय लॉर्ड टेक पैराग्राफ 3 ऑफ द प्लेंट। व्हाट इज द प्लीडिंग ऑफ द प्लेंटिफ, कैन ही गो बियॉन्ड द प्लीडिंग? नाउ शंकर महतो वाज द एब्सोल्यूट ओनर, इट हैज बीन रिटेन परहैप्स, नाउ इट इज रिटेन दैट ही डाइड 1979। नाउ it has been pleaded that his daughter is Rohini Devi.
That's right. Correct.
Now, so far as जो my lord का ऑब्जर्वेशन था कि रियल ओनर कौन था, आप रियल ओनर से क्लेम कर रहे हैं कि नहीं कर रहे हैं, रियल ओनर वो दोनों केस में दोनों का सेम है, वो पैरा 10 ऑफ WS का देखा है।
Yes.
The entire share of the said Shankar Paratin was transferred. I'm thinking. It is denied that Rohini Devi was in possession of any land in RS plot number such and such of village Urumanji, Oraundi, and that any land in these plots was inherited by the said Rohini. Shankar Mahato had no lands in these plots in 1979. The entire share of said Shankar was transferred by the said Shankar to the defendant as far back as in 1960. This kindly see me.
So you are denying the title of Rohini Devi.
How can I am not in, why denying?
You are denying that she or that any of these two clauses
He was not in
inherited by
possession. Yes.
neither in possession
Yes.
nor inherited by Rohini.
Yes.
Right?
Yes. Why? Because
And then you say that it was transferred by Shankar Mehto in the year 1960.
yes. Now yes. So ultimately, so my lord's query was, specific query was whether I was claiming against the real owner or not. So my lord is
No, not only this, you have to claim against the real
That's why
owner.
my lord kindly see.
You are denying the title of the real owner.
Yes.
And you say that the property was already transferred.
Yes. So the specific query was who was the
For adverse possession, you have to
my lord,
acknowledge the
first,
title of
my
the
lord,
real
I
owner.
will come. लॉ पे तो तब ना आएगा हुजूर, अगर हमारा कोई केस फैक्ट में बनेगा, अगर केस ही नहीं बनेगा फैक्ट में तो लॉ पे क्या आर्गुमेंट कर पाएगा, नहीं कर पाएगा। नाउ काइंडली सी that is the reason that my lord, I have what just shown from the plane that who was the real actual owner. So Shankar Mahato was absolute owner as per the case of the plaintiff. Now, so far as they have stated that Shankar Mahato died and the property was inherited by Rohini. Now, what is my pleading? Kindly take paragraph 9 of the written statement. क्योंकि उनका शंकर महतो का डेथ होगा तभी रोहिणी देवी पास आएगा. Now, paragraph 9 of the written statement.
Yes.
It is denied that Shankar Mahato is dead. The said Shankar Mahato was convicted in a murder case sometimes in year 1971 or 72. And since then, his whereabouts are not known. It is emphatically denied that the suit land was in possession of the said Shankar till 1979 and Rohini had inherited the land of Shankar. Thereafter, para 10. I have already read, my lord, that the property was already transferred by Shankar since in the year 1960. Thereafter, this Shankar had shared to the extent of 0. Such and such acre with the plaintiff's claims to have purchased from Rohini. It is false that Shankar had or has any son or that the Shankars have sold any land in these plots. Thereafter, my lord, kindly see paragraph 12. Third line. The defendant is in possession of the land purchased by him from Shankar Mahato in the year 1969.
1960.
1960.
This is the same thing.
Well, selling on the basis of these defendant claims. Unregistered document.
Maybe unregistered.
Yes.
But,
So
but he is claiming the property on the basis of a sale deed.
Sale deed from Shankar Mahato.
From Shankar.
And there is a specific pleading that the defendant is in possession since 1960. Now, my lord, can
So
you see?
therefore,
Yes.
when the defendant is claiming the property by virtue of a sale deed executed by Shankar Mahato, right? He is exerting his title on the basis of a sale deed. Correct? He is not acknowledging the title of Shankar.
No.
Yes.
He is acknowledging.
The original title.
No, my lord, we do
The
respect, my lord.
existing title he is not acknowledging.
No, existing title of Rohini Devi not admitted.
Even Shankar Mahato not
No,
admitting.
no.
Because he
So, can you
says,
see?
आप ऐसे no क्या बोल रहे हैं?
My lord.
नहीं, let me just understand. ये no क्या है?
My lord, because
You are claiming title on the basis of a sada sale deed of the year 1960.
From
Yes
Shankar-
or no?
yes, from Shankar Mahato.
From Shankar. So
my
on the
lord,
date you filed your written statement, you denied the title of Shankar Mahato from 1960. Yes or no?
yes.
Matter X?
नहीं, better my lord, can you see, my lord?
Evidence lordship में kindly also see lordship.
हाँ, नहीं अगर
Evidence.
हाँ,
एक लाइन kindly
हाँ,
evidence
नहीं,
दिखा देते हैं.
नहीं, पहले हमको इन्हीं से समझना
नहीं, हम समझ
हमको तो बेसिक इंग्रेडिएंट्स ऑफ एडवर्स पोजीशन इनसे समझना क्या
नहीं, हम उसमें लॉ पे हम तभी आ पाएंगे जब हम फैक्ट पे
तो ये फैक्ट तो सही है ना
हाँ ये
आप एग्जिबिट बी से अपना टाइटल क्लेम कर रहे हैं
हाँ
राइट यू आर asserting that it is a valid deed
हाँ
right and then you say that Shankar Mahato was divested of his title by virtue of exhibit B and then you came in possession by virtue of exhibit B since 1960
हाँ
that is your case
हाँ
वो तो अलग बात है कि एडजुडिकेशन में पता चला
हम
this is
कन्वे
not
हम कन्वे
admissible.
नहीं कर पाए मेरा क्या करना था माय सबमिशन माय लॉर्ड कि आई कैन नॉट डिनाई टाइटल ऑफ शंकर महतो क्योंकि शंकर महतो तो ओनर है ना और शंकर महतो से एग्जीक्यूट भी हम लिए तो हम शंकर महतो के राइट को कैसे डिनाई कर सकते हैं ये है मेरा कहना शंकर महतो की तो राइट को
शंकर महतो के राइट को आप ऐसे डिनाई कर सकते हैं कि शंकर महतो ने हमें बेच दिया तो उसका राइट खत्म हो गया बेचने का क्या मतलब है
हाँ ठीक
He is divested of his right.
माय लॉर्ड मतलब बट
ओरिजिनल रिकॉर्डेड पेमेंट 10 आदमी को
I
बेच
make
देगा
apology, my lord. My lord is correct, my lord. So my lord, I am claim my lord is correct. That is my point also. दैट इज माय पॉइंट ऑफ। तो शंकर महतो से एग्जिबिट बी के थ्रू है। अब हम ये रिकॉर्ड से दिखाना होगा कि नहीं सर दिखाना चाहिए
नहीं आप ही दिखाइए कि एडवर्स पोजीशन का प्ली कहाँ से कौन सा स्टेटमेंट हम एडवर्स पोजीशन का प्ली डिराइव करें।
नहीं now thereafter my lord can be
You are claiming title. You are claiming title over the property,
हाँ,
not adverse possession.
नहीं हाँ ठीक है जो ठीक है लेकिन मेरा एक चीज़ का है कि चूंकि एग्जिबिट भी आई जस्ट माय सबमिशन आई एम नॉट सेइंग जो केस उससे बियॉन्ड तो नहीं जाएंगे ना। मेरा सबमिशन है कि 1960 में शंकर महतो एक अनरजिस्टर्ड डॉक्यूमेंट से दे दिए और हम उसके पोजीशन में मतलब जब तक मेरे पास रजिस्टर्ड डॉक्यूमेंट नहीं आएगा तब तक तो मेरा हमारे लॉ के बियॉन्ड आर्गूमेंट नहीं करेंगे। मतलब जब तक मेरे पास रजिस्टर्ड डॉक्यूमेंट नहीं आएगा आई कैन नॉट क्लेम दैट बाय वर्च्यू ऑफ दिस अनरजिस्टर्ड डॉक्यूमेंट टाइटल केम टू।
But you have claimed.
टाइटल नॉट मतलब राइट।
You have claimed title. Please do not. The property was sold to you by virtue of
Claiming title.
You are claiming title.
एक मिनट kindly grant me some time sir just looking into the details.
You see, the Shankar was transferred by himself to defendant number as back as in the 90. The entire share of State Shankar was transferred
yes
by himself to the defendant as back as in the year 1960.
60
तो
तो मतलब ये कहना है कि मेरे वही मेरा थोड़ा डिफरेंट हम आई कुड नॉट अंडरस्टैंड विद ब्लीडिंग मेथड नाउ दैट्स व्हाई आई एम सेइंग दैट दिस डिफेंडेंट इज क्लेमिंग दैट the whatever the share of Shankar was it was transferred to me.
he's claiming title.
Claiming title मतलब yes claiming title but my submission that kindly on the basis of an unregistered document the plaintiff this defendant is claiming that whatever the right was
Not that. You are claiming title by virtue of an unregistered sale deed,
मतलब
which was exhibited also, that was marked exhibit B.
I may be perhaps from the written statement I have nowhere found that this defendant is claiming stated that the defendant has acquired valid title from
Valid title.
has not acquired title.
Transfer किसको बोलते हैं?
ये ट्रांसफर है जो लेकिन अगर देखेंगे हम इसीलिए कर रहे हैं कि ये नहीं कहा इसीलिए हम कर रहे हैं क्योंकि अगर चूंकि
समझ गए आपके पास कहने के लिए कुछ नहीं।
नहीं ऐसा
आप
नहीं
जरा देखिए ना पैरा 13 में पढ़िए ना
हाँ।
the sale deed executed by Shankar Mehto is genuine
हाँ
and through this sale deed Shankar Mehto transferred land
हाँ
to the
इसीलिए
defendant on payment of adequate consideration.
यस
क्या बोल रहे हैं आप?
नहीं हम बोले इसीलिए कह रहे हैं
And this consideration was also not.
yes this was the now हम क्या करें केवल एक बार सुन लिया जाए। हम ये कह रहे हैं कि पूरा रिटेन स्टेटमेंट में देखा जाए हमने ये कहा कि एक डॉक्यूमेंट एक्सिक्यूट किए सेल डीड है वो उसका कंसीडरेशन हम पेमेंट किए हम पोजीशन पे आए। अब इसके बाद देखा जाए माय लॉर्ड ये पैराग्राफ 2 of the written statement
Two में तो adverse possession का use.
केवल ये ना अब जो माइलॉट का कहना था कि हमको समझ क्योंकि हमको लगता है कि एडवर्स पोजीशन के थ्रू अगर हम टाइटल क्लेम कर रहे हैं कि रोहिणी देवी कोई राइट नहीं मिला और शंकर महतो से मिल गया तो हमको ये दिखाना होगा कि क्या इस बेसिस पे जो 1960 में जो एक डॉक्यूमेंट अनरजिस्टर्ड आया उसके बेसिस पे मेरा पोजीशन जो प्रिस्क्राइब्ड कंडीशंस है उसको फुलफिल किया या नहीं किया। अगर किया तो ठीक है नहीं किया तो नहीं है।
That a condition for claiming adverse possession. Mere use of word is not sufficient.
ना
What are the basic ingredients for claiming adverse possession?
यस नाउ kindly
First ingredient is that you have to acknowledge that it is not your title. First ingredient, you have to acknowledge the title of the true owner, and you have to say कि इस owner के खिलाफ आपका title पर because of adverse possession. And now the law is also well settled. If you claim title, you cannot claim adverse possession because it is conflict. You are claiming title and possession from the same date भी अलग नहीं.
नहीं, अब एक चूंकि हियरिंग है इसलिए हम एक्सप्लेन करना चाहते हैं. ये सूट लाए कौन देखा जाए, सुब्रू देवी लाई.
देखिए आप ना सब्सटैंशियल क्वेश्चन ऑफ लॉ के बियॉन्ड तो नहीं
नहीं जा सकते. इसमें क्या है? हाँ, नहीं.
पहला सब्सटैंशियल क्वेश्चन ऑफ लॉ है whether the heirs of exhibit B, whether on the basis of exhibit B the defendant acquired any right, title and interest over the suit property. इसमें तो कोई डाउट नहीं है कि हम रजिस्टर्ड डॉक्यूमेंट्स आपको नहीं मिल सकते.
हम बियॉन्ड कैसे
तो ये तो ऐसे ही खत्म. ठीक है. उसके बाद whether the finding of adverse possession of the defendant is based on the material on record.
बस ये.
Material also includes the plain and the written statement.
Yes.
Right?
Yes.
ये फाउंडेशन फीडिंग ही नहीं है तो कोई भी मटेरियल का क्या रेलेवेंस है. जब फाउंडेशनल प्ली ही नहीं है तो कोई इशू भी नहीं बना है एडवर्स पोजीशन. यू जस्ट लुक एट इट. देयर इज नो इशू ऑफ एडवर्स पोजीशन. नॉट फ्रेंड. न प्ली है ना इशू.
Then this substantial issue, this substantial question of law does not arise.
जो बना है तो आंसर कर रहे हैं.
तो इसी थोड़ा सा
इसीलिए बेस्ड ऑन मटेरियल ऑन रिकॉर्ड ना
हम रिकॉर्ड दिखाना चाह रहे हैं.
बेस्ड ऑन मटेरियल ऑन रिकॉर्ड बात बस उतना ही आंसर करेंगे. उसके बाद जो होगा वो होगा.
ठीक ठीक. अब एक बार एविडेंस देखते हैं. आने का तो दिखा दी.
DW4. DW4 in part 22 lordship stated that so far as adverse possession is concerned, विवादित जमीन पर मेरा घर होने का प्रमाण मेरे पास कागजी सबूत नहीं है. अपने बोलने के मेरा कोई घर नहीं है.
DW4 is the
legal years of the original defendants. They himself admitted that मेरे पास कोई कागजी सबूत नहीं है वहाँ मेरा घर है कि नहीं. This is my submission. Para 22 lords. May I give those? Sir. Para 22 lords.
म्यूटेशन भी नहीं
हुआ है.
म्यूटेशन
अब हुआ है.
हाँ उसके फाइंडिंग्स देखा जाए तो पता ही नहीं चल रहा है किसके नाम से है. और ओवर राइटिंग किया हुआ फाइंडिंग्स आया हुआ है. ओवर राइटिंग किया हुआ है. ओवर राइटिंग किया हुआ है.
जो है
एक जजमेंट और है कि अगर रिलीफ नहीं क्लेम करेंगे तो उसका क्या कंसिक्वेंसेस होगी। पैरा 4 लॉट से देते हैं मार्क किए हुए पैरा 4 The party cannot be granted relief if it is not claimed. If the circumstances of the case are such that granting such relief would result in serious prejudice to the interested party and deprive him of the valuable right under the statute. In an action by the landlord, the tenant expected to defend only the claim made against him. And if the cause of action arises to the landlord on the basis of plea set up by the tenant, in such action it is necessary that landlord seeks to impose the cause of action in the same proceeding by the suit at the amendment or by separate proceeding to entitle the landlord to relief on the basis of cause of action. The principle is that court is mold the relief taking into consideration subsequent immediate not applicable in such cases. In this case, no relief was claimed for advance position law.
आप एप्लीकेट कोर्ट का जजमेंट प्लेस कर लेते हैं
जी पैरा 2 लॉट जी
2 and 12 के बेसिस में बोला है कि दैट दे द प्ली ऑफ
यस
पैरा 2 में तो जस्ट अ वर्ड इज यूज्ड एंड 12 में purchased by him from Shankar.
admitted the title.
Shankar Mehta had put him in possession, adequate consideration. क्या बोलूं?
Well, sometimes I personally feel that I may be some in difficulty with the records. Record means what record says. Now, since my Lord always grant opportunity, that's why I can have any right
You
to
can
submit anything.
That's
Otherwise,
that's
otherwise.
you have your duty also to submit.
Yes. Now kindly, I'm deeply on that. Now kindly
लेकिन
take.
ये बार-बार नो बोलने का जरूरत
नहीं, मतलब
एक तो सबसे बड़ी बात क्या है कि पूरा आर्गुमेंट खत्म होने के बाद आप तो आप तो थे ही नहीं जब आर्गुमेंट हो रहा था ये इस तरह के मैटर्स जब फाइनल हियरिंग के कोई भी मैटर यू हैव टू सी व्हाट अपीलेंट इज आर्गुइंग और पूरा प्लेस कर दिया उन्होंने पूरा स्टेटमेंट प्लेस कर दिया सब कुछ सडनली यू come and then you
we have certain personal difficulties. That's when I am appearing from the respondents. I was arguing in a court. I conveyed that time.
pass over का prayer भी नहीं
हम कहे इसीलिए कि short I was there but my
नहीं था prayer
वो नहीं हो पाया. That there is fault on my part. Now kindly take two things. There, they are the plaintiff and this Jaidev Mahato is the defendant. Name is important. Jaidev Mahato. Now, under their case, in para 5, 4 and 5 that Rohini Devi is the only legal heir and successor of Shankar Mahto. My lord has perhaps noted it also, who inherited the property left by her father Shankar. And thereafter the pleading is that Rohini Devi remained in possession over the land with her full right, title, interest, executed a registered deed of sale in favor of plaintiff.
Who executed the sale?
Rohini Devi, plaintiff, I am reading claim, their claim. So the plaintiff is claiming title on the basis of registered deed of sale on a pleading that Rohini Devi had a right title and he transferred the lands to the plaintiffs. So, my lord, as per the case of the plaintiff, who has to stand on their own legs, there is that Rohini Devi was the actual owner. This is my first submission. Now, second submission, my lord, that in the written statement, the defendant had pleaded in para 10, my lord has also taken note of it, that Rohini Devi has not inherited the lands of fruit land has not been inherited by Rohini Devi, and so far as the right title of plaintiff in their claim, it has been denied in a cut short. In para 2, only ornamental word adverse possession has been used. Thereafter, my lord, in para 12 of the written statement, there is a specific pleading of the defendant, para 12, that the defendant is in possession of the lands purchased by him from Shankar Mahto in the year 1960. Now, my lord, I have to show from on the basis of these pleadings, my lord, kindly take the decision relied by my senior, my lord, reported in 2006 Supreme, my lord, it is with the my lord.
Yes, what do you want to say?
From there, the judgment of the
2006.
Supreme
7
page,
SCC, page 57.
page 752. Page 752.
752 में कोई जजमेंट नहीं दिया.
570.
ये अच्छा, इसमें पैरा 15 पे रिलाय किया जो जो कॉपी है हमारे पास,
हाँ.
वो पैरा 15 हम गलत होता है, ऊपर भी लिखा मिनट लास्ट लाइन में पैराग्राफ 15. Paragraph 15. Adverse position means internal page 5. Adverse position means a hostile position which is expressly or impliedly. The word used is method.
Yes, please.
The word used is expressly or impliedly. Both the words. In denial of title of the true owner. Under Article 65 of the Limitation Act, burden is on the defendants to prove affirmatively. A person who bases his title on adverse position must show, this line is very important. The person who bases his title on adverse position must show by clear and unequivocal evidence that his possession was hostile to the real owner and amounted to a denial of his title to the property claimed. In deciding whether the acts alleged by the person constitute adverse possession, regard must be had to the animus of the person doing those acts, which must be ascertained from the facts and circumstances of each case. The person who bases his title on adverse possession therefore must show by clear and unequivocal evidence that his possession was hostile to the real owner and amounted to a denial of the title. Now, we will kindly take evidence.
That's all.
Kindly take evidence
Whose evidence? And for what purpose?
for purpose to show. That's why I perhaps I could not convey the ratio of the Honorable Apex Court, wherein in 2006 Supreme Court, wherein it has been held by the Honorable Apex Court that from the evidences unequivocally it should be shown that the defendant who is asserting adverse possession, that his possession was hostile to the true.
फाउंडेशनल प्लीडिंग ही नहीं है तो पार्टी का काम ही बेकार है.
ठीक है मतलब फिर मेरे केवल इसको नोट कर लिया जाए. Kindly take note. The best evidence that this defendant has acquired any right and whether Shankar Mathur has transferred thereafter, whether Rohini Devi has any right, whether Rohini Devi was owner who has the best evidence? The best evidence that whether as per case of the plaintiff or not, that Rohini Devi was the true owner. He had a title, he had right, he transferred the property to the plaintiffs. That is my submission. As from their claim. Now, the best evidence to prove that Rohini Devi had any right and whether the in right to the of the Rohini Devi certain acts have been exercised which was hostile in the nature by the defendant or not. Now kindly take the best evidence, Rohini Mata. She had been examined as PW.
So what do you want to say from it?
Paragraph 7. From this evidence, my lord, I am showing
Para 7.
और भी है उन्हीं का
एक ही बार में सारा पैराग्राफ नंबर बताइए फिर हम देखेंगे। एक बार में सारा पैराग्राफ नंबर
मतलब I will see मतलब if my lord
ऑर्डर
will
में लिखाना पड़ता है that you are
Paragraph
referred to
7.
such and such
see my lord
paragraph.
paragraph 7
7,
my lord 11
11,
paragraph 12
12,
paragraph 15 thereafter my lord PW2
who is PW?
Manbodh
Sorry,
Manbodh
and who is he related? How is he related?
my lord that is plaintiff's witness my lord I can show from the record from the
You want all the evidences to be
ना
examined?
नहीं बस दो है
PW का
PW
पैरा बताइए। इस तरह से जो सब्सटैंशियल क्वेश्चन ऑफ लॉ बनता है ना मटेरियल ऑन रिकॉर्ड, ये फर्स्ट अपील का भी डबल फर्स्ट अपील बन जाता है।
इसको थोड़ा बड़ा कर देता है
इसको बड़ा नहीं पूरा ओपन कर देता है। तो ये सेकंड अपील क्या रह गया इसमें?
सेक्शन 100 का कैसे आई बोलो
क्या ये सेक्शन 100 में या तो सब्सटैंशियल क्वेश्चन ऑफ लॉ फ्रेमिंग के अगेंस्ट में लोग जाते ही नहीं।
certain difficulty my lord since
पैरा नंबर बताओ।
PW2 my lord paragraph 7
7
now my lord PW1 Rohini Mata who as per the plaintiff was the owner she has admitted in his cross examination in paragraph 7
क्रॉस एग्जामिनेशन पैरा 7 से शुरू होता है।
नहीं पैराग्राफ केवल जो रेफर कर रहे ना सिंस माय लॉर्ड कहना था जो दिखाना चाहते हैं वही दिखाइए वही हम दिखा रहे हैं डिफिकल्टी कुछ भी नहीं था माय लॉर्ड सिंस हम लोगों ने नोट किया है उसके बाद जो असिस्ट कर पा रहे हैं पैरा 7 में है अगर हम गलत नहीं लिखे हैं मेरे पिताजी 12 थाना सोनाहातू रांची में मकान बनाए थे उसी में मेरी शादी हुई है नेक्स्ट 12 में पिताजी को उराव डी वाला अपना कपड़ा बांस से घर बनाया तब जयदेव my lord has taken down that the defendant is जयदेव तब जयदेव ने मेरे पिताजी के बाउंड्री में उक्त घर बनवाया thereafter kindly take note that death of para 11 by referring paragraph 11 and 12 para 15 referring छोटू के मकान के सटे पूरा प्रतिवादी जयदेव का मकान है एंड PW2 मंजूर पैरा 7 विवादी जमीन में कुआं कच्चा है और कुआं जयदेव ने बनाया so there admission on the part of the plaintiffs that certain acts had been done which was hostile to the true owner Rohini Devi, and it has been admitted by them in evidence. Now, apart from that, my lord, two documentary evidences, Exhibit A series and Exhibit D, has also been filed. Exhibit 1 series rent receipts, which is in the name of the defendant, and
Exhibit A series.
A series, and Exhibit D.
D series क्या?
A series A
D series.
D नहीं है, केवल D है. ये ड्राफ्ट खतियान.
आप कहाँ से कहाँ जा रहे
नहीं.
हैं? आप ड्राफ्ट खतियान में पहुँच गए हैं।
हम इसलिए दिखा
भाई
रहे हैं.
आके इसे there is a limit to it.
नहीं, डिबेट नहीं कर रहे. हम क्या कर रहे हैं? हम केवल
आप एडवर्स पोजीशन में और एग्जिबिट बी में कन्फाइन करिए, बाकी कोई चीज में मत जाइए. I will not permit you to, reopen every issue and then create a new issue and then argue the case.
इसलिए हम तो I outside admitted that
Some acts have been done. This is what we want to see.
yes, by referring to this, nothing more. But I have no exhibit. I am not going to show. Just referring those matter with relation to substantial question. That's all.
पोजीशन डिपेंडेंट का है तभी ना रिकवरी का ऑर्डर हुआ था. नहीं तो रिकवरी का ऑर्डर है, आपका पोजीशन है, इसमें कहाँ कोई डिस्प्यूट है. नहीं तो एडवर्स पोजीशन की क्या कहानी. ट्रायल कोर्ट हैड डिक्रीड द सूट एंड आल्सो डायरेक्टेड फॉर गिविंग पोजीशन. सो योर पोजीशन इज नॉट इन डिस्प्यूट, बट द पॉइंट इज वेदर इट वाज एडवर्स.
Hostile or not, yes. So
नहीं,
इसीलिए रेफरेंस दिए.
इसीलिए ये जो एक्ट्स ऑफ सम ओनरशिप या एक्ट्स ऑफ ये तो दिस इज एडमिटेड, अदरवाइज तो कैसे ही होगा.
तो अगर एक्ट ऑफ हॉस्टाइल पोजीशन इज एडमिटेड.
Hostile, not possession. Act of some kind of possession. Hostile possession is a legal term.
Yes.
ये कोई इंग्लिश वर्ड नहीं है. It's a legal term.
Legal.
Adverse possession is also a legal term.
Legal.
उसका बेसिक इंग्रेडिएंट का प्लीडिंग तो होना ही चाहिए.
My submission that sometimes our hands are very tight.
I know. पुराने जमाने का पिटिशंस है, उस जमाने के हिसाब से बना
But
होगा.
even though I want to justify my presence
Your presence is fully justified.
by the minors.
Heard the learned counsel appearing on behalf of the parties. This appeal has been admitted for final hearing by the order dated 2/11/1995 on the following two substantial questions of law. A. Whether on the basis of the Exhibit B, the defendant acquired any right, title and interest over the suit land. B. Whether the finding of adverse possession of the defendant is based on materials on record. The suit was filed by the plaintiff seeking declaration of their right, title and interest over the suit land and for confirmation of their possession and for delivery of the same if found dispossessed. इसको एक तो छोटा बनाते हैं. ये ए में तो आपको कुछ नहीं बोलना है. ए में तो कुछ नहीं बोलना है.
कंसेशन.
कंसेशन क्या? कंसेशन नहीं रिकॉर्ड करेंगे. बट यू हैव नथिंग टू से. व्हाट कैन यू से फॉर एन अनरजिस्टर्ड सेलिड कन्फरिंग टाइटल? डू यू हैव एनीथिंग टू से? आई विल रिकॉर्ड इट. नहीं है ना. So far as the substantial question of law number A is concerned, the learned counsel for the appellant has submitted that the law is well settled that immovable property cannot be transferred by way of unregistered sale. He has submitted that the defendant in the written statement had claimed title on the basis of unregistered sale deed of the year 1960, which was exhibited as Exhibit B. The learned counsel submits that finding was recorded that even the sale consideration did not pass pursuant to Exhibit B. However, he submits that Exhibit B being unregistered, no title can pass through Exhibit B,
Which is required to be registered.
which is compulsorily registered. The value of the consideration amount
Is 3.
as mentioned in Exhibit B itself is rupees 300.
300.
300. Although the learned counsel for the respondent has opposed the submission, but being a counsel and first an officer of the court, he also does not dispute.
Section 17, yes.
He also does not dispute that right, title and interest with respect to immovable property having value of more than rupees 100 cannot be transferred by unregistered sale deed. In view of the aforesaid submission, this court has no hesitation to hold that on the basis of Exhibit B, the defendant has not acquired any right, title and interest over the suit. This takes us to the second substantial question of law. The learned counsel for the appellant has submitted that upon reading of the written statement filed by the defendant, it is clear that the defendant was claiming title by virtue of the unregistered sale deed executed by Shankar Mehto in favor of the defendant against consideration amount. The learned counsel has also submitted that the defendant had claimed possession by virtue of the unregistered sale deed. The learned counsel has further submitted that though the defendant has mentioned the term adverse possession in paragraph 2 of the written statement, and so far as the other pleadings are concerned, the same was based on his title deriving from Exhibit B and also claiming possession by virtue of Exhibit B. There was no foundational pleading with respect to adverse possession. He submits that the defendant never acknowledged the title of the true owner, and the law is well settled by now that adverse possession and title, both being contradictory, cannot be claimed, particularly when it refers to the same date of possession. The learned counsel submits that the trial court had recorded a clear finding that there was no foundational plea of adverse possession, but the learned first appellate court had referred to paragraph 2 and 3 of the written statement to say that the plea of adverse possession was taken. He submits that upon reading of paragraph 2 and 12 of the written statement, it cannot be said that the plea of adverse possession has been taken. This is over and above the fact that the plea of title is contrary and in conflict with the plea of adverse possession. The learned counsel submits that in absence of any foundational pleading seeking adverse possession and the basic ingredients to claim adverse possession having not been pleaded, the learned first appellate court was not justified in decreeing the suit on the ground of adverse possession. Although the learned first appellate court had not conferred title on the basis of exhibit B. Exhibit B में title तो नहीं दिया ना. The learned counsel for the respondent, on the other hand, has opposed the prayer and has submitted that the plaintiff claimed title on the basis of sale deed executed by Rohini Devi. Two registered sale deed executed by Rohini Devi, daughter of Shankar Mehta. And it is not in dispute that Shankar Mehta was the owner of the property. He has also submitted that although it was claimed that Shankar Mehta had died in the year 1979, but this fact was denied by the defendants. He has also submitted that Rohini Devi was examined as PW1, and from perusal of paragraph 7, 11, 12 and 15, it appears that the defendant, namely Jaidev Mehta, was in possession. And for that purpose, he has also referred to the evidence of PW2 parasite. The learned counsel has submitted that there was enough material on record to show that the plaintiff, that the defendant, Jaidev Mehta, had perfected his title by way of adverse possession. It is all appellant. The appellant has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2006, bracket 07, SCC 570, paragraph 15, bracket 1991, bracket 1, SCC 441, paragraph 4. ये तो पैरा 4 आपने रिलाइट किया 1990 का
नहीं हाँ किया
केवल 2006 का पैरा 15
हाँ that 1982 AIR Patna 185 para 6 to submit that mere long possession is not adverse possession and adverse possession must be specifically pleaded and proved. In 2019 bracket 8 SCC 729 para 57. The learned counsel for the respondent has also relied upon para number 15 of the judgment reported in bracket 2006 bracket 7 SCC 570 and has submitted that it has been held at the end of the paragraph that the person who bases his title on adverse possession must show by clear and unequivocal evidence that his possession was hostile to the real owner and amounted to denial of his title to the property claimed. He submits that the basic ingredients of adverse possession has been satisfied.
Pleaded also manipulated.
And it was based on form ratio pleading and the evidence led before the court. After hearing the learned counsel for the findings, this court finds that the plaintiff was claiming title by way of registered deeds executed by Rohini Devi, daughter of Shankar Mehta, and that Shankar Mehta had expired in the year 1979. On the other hand, the defendant, though stated in paragraph 2 that the suit was barred by limitation and adverse possession, and denied the death of Shankar Mehta, but asserted that Shankar Mehta had transferred the suit property in toto to the defendant in the year 1960 by making payment of consideration amount. And that the defendant had built a house over the suit property. Some of the relevant paragraphs of the written statement are quoted as under. Paragraph 2. Then no, 10, 12, 13. And 1. The learned trial court had framed the following issues for consideration. So far as the issue number 4 is concerned, issue number 3 and 4 were taken up together. The learned trial court considered the materials on record and held that कहाँ पे लिखा है सेंडीड के बारे में, एग्जिबिट बी के बारे में?
Para 5 minutes. Let me try to. And para ये findings आया है. Page 8 में how may he have come and prove it. Thus the apostle state of land is concerned without proper consideration is not only void in issue but invalid in the eye. Page 8.
We are against you finding parasa trial. We are against you finding
I've already said it is void ab initio. The learned trial court recorded that not only exhibit B was without any consideration and was void ab initio, but admittedly the same was an unregistered document. And therefore the claim of the defendant on the basis of exhibit B, Sada Sendid, is hit by the provisions of section 17 and 59 of the Registration Act. The learned court thereafter recorded that the defendant had tried much to prove his possession adverse to the plaintiff, but there was no foundational pleading. The learned court ultimately held that the defendant was a trespasser and observed that the plaintiff was claiming title on the basis of registered sale deed number 4609 dated 31/3/1971 and number 18422 dated 30/12/1974 in Unit 1 and 1/2. The court held that Rohini had rightly sold her property to late Gauri Mehta and the issues were decided in favor of the plaintiff except on the point of possession. However, the court also observed that
एडवर्स पोजीशन पेज 11 पर है।
sorry,
पेज 11 पर है एडवर्स पोजीशन पर पेज 11
the plea of adverse possession was rejected.
in the present case though the defendant has tried must prove his position adverse to the plaintiff yet he is pleading but do not mention the adverse position specifically. Page 11.
The learned court ultimately directed retrieved the suit and directed the defendant to deliver the possession of the suit property to the plaintiff forthwith. The learned first appellate court framed the following points for determination at paragraph 6. While considering the point number 2, the court the point number 1 and 2 both were taken together and the court held that though the learned court has mentioned in the judgment, trial court has mentioned in the judgment that the plea of adverse possession was not taken in the written statement. So we would not be allowed to take the plea of adverse possession in evidence. However, the court referred to written statement para 2 and 12 to observe that it was clear that the plea of adverse possession and limitation was taken at the very initial stage. The court also recorded the submission of the defendant that though unregistered document which was compulsorily registrable under section 17 of the Registration Act could not be admitted in proof of the terms embodied in it and do not confer any title to the transferee of the property, yet its possession is a proof that the possession was delivered. Thereafter, the court referred to Exhibit B and observed that the sale was the learned court recorded the finding in paragraph 9 of the judgment. And ultimately, the court was of the view that, in paragraph 12, the court was of the view that the defendant was able to establish his claim of adverse possession and the plaintiff was precluded from enforcing right against the defendant. The finding of the learned trial court in deciding issue number 3, 4 and 5 was held to be erroneous. So far as the second substantial question of law is concerned, which is relating to adverse possession, upon complete reading of the written statement, this court finds that the plaintiff was claiming title with respect to the sued property on the basis of Sada Sale Deed of the year 1970 and also claimed possession pursuant to the Sada Sale Deed. The plaintiff claimed that Shankar Mehto had transferred the property to the defendant. The defendant claimed that the Shankar Mehto had transferred the property to the defendant on payment of adequate consideration. Even as per the Sada Sale Deed, the consideration amount was rupees 300. इसमें तो कोई doubt नहीं. Was rupees 300, and certainly the same was compulsorily registered. except the word adverse possession used in paragraph 2 as an ornamental pleading, there was complete lack of basic pleadings so far as adverse possession is concerned. It is also important to note that the defendant never acknowledged the title of Shankar Mehta in the written statement. The law is well settled that in order to claim adverse possession, one has to acknowledge the title of the true owner and claim adverse possession thereafter. The law is also equally well settled that the plea of adverse possession and title are conflicting and cannot be claimed simultaneously. The law is equally well settled that long possession is not equivalent to adverse possession. Considering the written statement, this court is of the view that the learned trial court had rightly observed that the plea of adverse possession was missing in the written statement. In absence of foundational plea of adverse possession, no evidence can be put. The law is equally well settled that the plea of adverse possession is not only required to be pleaded and also proved. In view of the aforesaid facts and circumstances, this court is of the view that the finding of adverse possession as allowed by the first appellate court in favor of the defendant is not sustainable. Both the substantial question of law having been answered in favor of the appellant, the judgment passed by the first appellate court in favor of citizens. Does it happen this way?
Detailed.
बस सेकंड अपीलेट कोर्ट का जजमेंट सेट असाइड होगा बस सेकंड अपीलेट कोर्ट मतलब फर्स्ट अपीलेट कोर्ट का ही जजमेंट सेट
The date is for final dismissal item 3, first appeal 4 of 2014, along with item 4 to 6.
What is it?
It's for final hearing land acquisition.
Six and 7, both these matters are there. No? You start your argument. आप respondent की तरफ से. Only 2 cases are on board.
All the cases. 4 cases.
4 cases. आप start करें.
Just praying for the day.
Place the judgment. For that also you need your senior. What is your case? You are agreeing with the quantum? Only the quantum is involved? Rate of land.
Yes. We say that there is no basis for determining the compensation. No
So-
exhibits.
So no compensation is paid.
No exhibits. We have decided a rate chart. We have exhibited documents for that rate chart. And it should have remained the same on the basis of rate chart, unless some documents should have been brought by the claimants, which has not been.
No material was brought.
No material.
Let us see.
No relevant material of that village.
Okay. This is under old act.
Yes.
Let us see. You just read para 3. What was the case of the claimants? What is the date of notification?
13/1/1981.
4. Then 7 is
7 is 28/4/1982.
8. 9 is 13/9/83.
The village that is under consideration is village Pindera. There are
Village is Pindera. Where is it mentioned?
It is in the
Pindera. Para 3.
as well as para 1.
Acquired by common.
There are the Bune judgment has 5 reference cases, out of which 4 have come under appeal. In the first page, reference case number 50 of 95.
It is common fact that the acquired land is surrounded by adjacent collieries. Right?
It's a
Am I going on? And these lands are just besides the national highway. This is also a common fact.
no. This is the statement by the claimant.
Okay.
This is the land reference.
Now let us see the evidences.
Para number 7 is point 1 and 2.
That's right.
So here are the admitted facts that has been stated in para 9.
The rate chart is mentioned.
The rate chart has been mentioned, which is on the basis of exhibit D that has been stated.
That's right.
Then it is admitted in addition to the rate mentioned, solution at 30%, interest at 9% for first year and 15% for subsequent years.
That's right.
There is additional compensation at 12% for the period between date of publication to the section 9. The amount has been received with protest. Page 5, point number 10. In light of the above admitted facts, I would like to discuss the evidence adduced by the parties. Applicant witness number 1 states ECL has given very less compensation, though it requires 3,500 per decimal. Further, he states that said land is well developed land. Similarly, applicant witness number 2 states land developed land, it is having value at 3,500 per decimal. Applicant witness number 3 and 4 have also corroborated same facts. Applicant number 5 states that this case has been fixed for enhanced compensation, but during evidence he has not disclosed the rate of compensation. Applicant witness number 6 states appropriate compensation will be 6,000 per decimal. Same fact has been corroborated by applicant witness number 7. In reference case 196, applicant himself has been examined as witness number 1. States acquired land is well developed land, which is admitted to collieries, and its compensation has been paid very less, which is required to be enhanced to 10,000 rupees per decimal. He has also given description of trees standing thereon at the time of acquisition and income he derived from. On the other hand, 4 witnesses have been examined by the OP in this case, who are found. OP 1 states the rate of compensation was fixed by specialists who have fixed it after assessment and inspection of land, and the rate of trees was also fixed as per fixed rate of government. Further, it states that as per rate available at the district registry office, rate of compensation was fixed according to the act and acquired land falls under coal mining area. On identification of witness, notification under section 914171 of the act has been marked as exhibit A by 1 and A by 2 respectively. At para 21, he states that all these fields are under West Bokaro coalfield area, which is running since 1974. OP number 2 has corroborated above evidence of OP1 and states para 5 that apart from appropriate compensatory evidence of OPW1, OPW4 has brought the case record of all these 5 reference cases which have been marked as exhibit B series. This B series is the document wherein as per the category of land and as per the rate chart, the compensation has been assessed for the lands as well as for the trees. During cross-examination at para 10, he states that land of village Pindera is under West Bokaro coal area. At para 12, he states acquisition was made for mining of coal. As documentary evidence, photocopy of true copy of judgment dated 31/3/95 passed by Honorable Court in respect to the appeal number 18/247 of 93, in which compensation of the land of village Layo was under consideration. Present case is village Pindera, which has been filed and marked exhibit 1. On this exhibit 1, the tribunal has decided the case. In that very case, tribunal has enhanced the rate of compensation at the rate 1200 per decimal, which was reduced by the Honorable Court. Your Honorable Court is the Honorable High Court. After considering all evidence, and it was fixed at the rate of ₹600 per decimal as flat rate related to all the acquired lands of village Layo without any classification. Said rate is inclusive of the rate of the trees standing on those lands. Exhibit 2 is the photocopy of the certified copy of judgment passed by Tribunal of 1/3/1994 under Coal Bearing Areas Act in respect to 16 reference cases related to lands of village Parej and Daru Kashmir. Again, these are 2 different lands. And after considering all the evidence, including said deed produced before the tribunal, a flat rate of 72,700 per acre was granted by the enhancement of the compensation awarded in respect to acquired land. Exhibit 2 is the photocopy of map of Mandu Anchal, which shows village Pindera is in the vicinity of village Parej and Daru Kashmir. It is very much clear from exhibit 1/A that in respect to land of village Parej and Daru Kashmir, rate was enhanced by tribunal and fixed at the rate 72,700 per acre. Same rate was also fixed by tribunal in judgment and awarded at 3992 passed in reference cases number 57 to 88 of 1989 in respect to the land related to village Layo, and it has been reduced by Honorable Court at the rate 600 per decimal, while exhibit 1. However, there is no evidence to show that exhibit 1/A has not been challenged before the Honorable High Court and it has got its finality. Though in this case, no any sale deed has been, this is the final. Though in this case, no any sale deed has been brought into evidence by any of the party to prove the prevailing market rate in the locality.
This is sale deed of the
Village
village is not there. But by virtue of judicial orders which have been passed in the vicinity of the area, that is village Parija and Daru Kharmar.
No document to no evidences to show, or that finding
Exhibit
has
2 is the photocopy of the map,
it has to be corroborated.
which is
A map
exhibit
would
map is enough. What corroboration is required? Map will show the boundary, no?
It should be now exhibit 1 is the Honorable Court's order for village Layo. It should, in that compensation
You forget about exhibit 1.
in that compensation case, the rate chart for that village Layo has been shown, which is different from this
No,
village.
you forget about village Layo.
All the
You
lands,
talk about these two.
so all
Village Pindara is in the vicinity of village Parij and Daru Kharmar.
similarly for Parej and Daru, all the lands are of different, although the category of land would be the same, but just being by virtue of them being in different areas, they are assessed at different rates. Therefore, the prevailing rate charts have been produced, and on that basis only different compensation was.
You have not exhibited anything. Did you
The
exhibit? Rate chart is enough.
The rate chart.
Rate chart is based on what? Is
chart
it based on what? On what is it based? Guys are exhibited this. That is exhibited?
Yes.
Rate chart is exhibited?
Yes, it's exhibit D.
Exhibit B.
D.
D.
It would not be out of place to mention that the appeal was filed by the claimants. First and foremost, it is the duty of the claimants, just like us, to prove their case. They should have brought documents on record to show
They have brought the documents on record of
of
nearby
a different
places.
village.
They have not been able to procure any salient of the same village.
So then evidences should have come stating that the villages are of the same, the lands are of the same quality. The judgments are there.
The judgment is also there that if the land of the same village is not available, then the land of rate of adjoining villages can be taken into consideration. That is also there. It is not only the compensation is not only fixed on the quality of land; it is also fixed on the basis of location of land, the area, right? Whether it is small area, large area, what is the
Now,
location?
exhibit 1 and 2, the judgments, in both those cases, now that value has been decided on basis of sale deeds.
Sale deeds must be of that area.
Now sale deeds of that area cannot be equated to sale deeds of this area.
It will not be. But if there is no sale deed available with respect to this area, you have not also exhibited any sale deed. Did you? No. They have also not exhibited any sale deed.
We have stated that the registry office rates were considered, and on that basis,
Registry office rate means circle rate.
No, the registry office, as in had
Registry office has the circle rate.
the circle rate as well as whatever registration has been done with respect to lands on those.
Show me from where? Where is you should have placed those registered sale deeds. What was the area? What was the location? Your rate chart is not an evidence. Is it an evidence?
It has been.
Rate chart by itself is nothing. If rate chart is based on some sale deeds, those sale deeds should have been exhibited. there is no reference of anything. Nothing is referred. What is the basis of this rate chart? There is no basis.
No, rate chart the basis is the registered dates.
Where from where do you read it? आपका स्टेटमेंट से थोड़ी चलेगा. रेट चार्ट से पढ़ते
जो बोनस तो उनके ऊपर था.
अरे भाई ओनर्स उनके ऊपर था. They have not been able to show me this rate chart. Have you seen the rate chart? Look at the rate chart. It is the rate is approved by the finance committee. That's it.
There is a discussion that from the same date the state authorities furnish
Yeah,
the
this
details.
is first step, no? So
Yes,
first
it
we
is filed in
get
the
the-
evidence only. Mentioned from the documents. And
Rate chart by itself
yes,
is not an evidence,
yes.
correct? So whatever was the basis to come to a finding in the rate chart, if there was any sale deed or if there was anything else, that should have been brought on record.
Also, there is another. Some compensation was paid. They were agreed. They have to prove also that what is the rate. If this is not the rate, then they will have to lead evidence to show.
They have laid it.
Also, they have led evidence. Can you see what evidence they have brought? They have brought on record the lordship's award prepared or the judgment of this honorable court with respect to a different village, and they have brought on record a map. The map does not even contain that 1 centimeter would be how many kilometers. So unless that is there, lordship in country's map, lordship sees Ranchi would be seen just next to Patna. Unless lordship that scale is given, and secondly lordship a difference of few kilometers will change the entire value of land. That your lordship can assess. The rate at Frailar cannot be lordship the rate 5 kilometers away from Frailar in any direction.
The law is well settled. If the sale deed of a particular area is not exhibited,
Yes.
not available, then under such circumstances, the adjoining villages can be taken.
Ashok, then there have to the evidence has to be laid. That first what was the value in the adjoining village, what was the value over here, and what
Evidence
is the
has been
proportion
led with respect to the judicial pronouncement with respect to the adjoining villages.
of the adjoining villages.
Yes.
Ashok, whether it is adjoining villages, what is the distance, what is the proximity of the adjoining village to the main road, what is the proximity of this village to the road, everything has to be seen. Lordship, for example, Lordship may take village as a small locality. Lordship, there may be a locality adjoining the main road, and
What's
there may be another
stopping you from
adjoining
reading
locality
it?
just
Why
behind.
didn't you bring any sale deed on record? One sale deed would have been sufficient. Only one sale deed would have been sufficient. You don't need more. But you have not taken any. No step has been taken from your end to justify your
Lordship,
compensation rate.
Lordship, first.
And this is in with respect to village
Pindera.
and all the land of the adjoining villages. क्या नाम है adjoining villages का?
Layo,
Parej and
Parej, Panchmo,
the two villages they have said
Layo
is
and
in the vicinity. Parej and Daru Kashmar and
Daru.
Daru Kashmar, right?
Yes.
they were acquired by the same notification. Same notification.
Maybe same notification.
Yes. Acquisition at one go by the same notification.
No, Raksha. One is of 1980 notification, that is Exhibit 1 Village Layo, and Daru Kasmar is Exhibit 2, 1981.
You just see the notification, the schedule, the part, you just have a look at it. This is notification 3983, has a schedule giving the detail of properties of all these villages at the same time. There is a limit to which you can help your client. There is a limit to which you can help your client.
Yes, I don't
Same
know.
notification, everything is
Maybe
same.
same notification. If it's
So
by a
a
same
large
notification.
chunk of land is being acquired at one go. The law is well settled. You see, some kind of guesswork has to be there. None of you have exhibited any same deed of the area. Now the court records that adjoining village, there is a judicial pronouncement, and then
Layo has not been acquired by this notification.
Layo has not been considered.
Layo has been considered.
No.
Rachima, can you come to paragraph 12?
You see, the court has recorded only with respect to two of the villages that they are in the adjoining. Only two villages are in the adjoining. Not all of them.
Exhibit 1 is Layo. What is related?
Maybe exhibit 1, but the court has not
Related
relied
on
upon.
exhibit 1 here.
No, you just have a look at it.
Para 12 and para 14.
Para 12 बाद में आप यहाँ पे आइए. You see, para 12 का bottom. Exhibit 2 is photocopy of the map of Manjul area, which shows that the village Pitara is in the vicinity of village Parija and Daru Kasmar. इन दोनों का जो भी होगा उतना भर तो कंसिडर करेंगे, आपका जो बाकी दूसरा को नहीं कंसिडर. पारिजा एंड दारू कमार का एग्जिबिट 1/A. एग्जिबिट 1/A.
और उसके बाद वो जो जजमेंट है, that also in that judgment so the honorable court has
कौन सा judgment?
जिसको कंसीडर किया है उसमें भी 20% डिडक्शन टुवर्ड्स ये डेवलपमेंट कॉस्ट परमिट किए हैं, which has not been done.
उस जजमेंट में 20%
Yes, that also
20% डिडक्शन करने के बाद ना रेट निकाले होंगे.
नहीं लोअर कोर्ट जो किए थे 72,000 किए थे, उसको दिस ऑनरेबल कोर्ट हैज रिड्यूस्ड इट टू 60,000 एंड 20% डिडक्शन टुवर्ड्स ये हैज रिमेन अनडिफाइंड
ओवर एंड अबव व्हाट वाज फिक्स्ड.
यस,
ठीक है, वो देख लेंगे हम लोग.
वो भी दिखा देंगे.
FA number 4 of 2014 with other analogous cases. The hearing of the cases have commenced. Post this case for further hearing on Monday,
Tuesday
on Tuesday at
2:15
at 4 o'clock. नहीं सर, वैसा नहीं हो सकता. 2:15 कल मंडे से ड्यूटी रहेगा. मंडे से सर 2:15 ड्यूटी रहेगा. इसी